You're on the record.
Good morning, everyone. We're here on the Pro Se Family Law docket for March 22nd. I'm Commissioner Dave Nelson. Let me call a couple matters that I think are going to be shorter. Ms. Davenport, I see you here. And based on what we did on the minor guardianship matter, which we put over to April 18th, I think this matter needs to be put over to April 19th. At 9 o'clock. Will that work? You're muted right now, Ms. Davenport.
Okay, I'm sorry. My phone, I'm on my way to work, and I thought we put it over for April 11th.
I think it was ultimately 18th because of everybody's schedule.
I'm here to help you answer any questions. Just put it on mute.
Okay, yeah, if we need to hold it over, that's okay. Are we allowed to, do I need to respond to his response or for this matter?
You're able to file any documents you'd like. So if you want to file a response, that's fine. Okay. All right, I'll see you back here then on April 19th at 9 o'clock. Okay. Thank you. So the first case will be John Gilbert and Aaron Gilbert. I know Mr. Gilbert's here in the courthouse. Mr. Lawrence is here, and
I'm
Ms.
here.
Gilbert is in her car. Last time we were here, I reiterated the requirement for the 12-panel hair follicle test and a substance abuse evaluation. Have either of those been done, Mr. Gilbert?
No, I said I couldn't afford it.
All right. Mr. Lawrence, have you been able to look into this case?
All I've done, Your Honor, is my initial investigation in this, and I checked yesterday to see if any documents had been filed, and there were none. I guess my suggestion at this point is that we simply leave status quo in place until Mr. Gilbert decides to comply with the court's orders, and then he can petition to have it reviewed.
That was one of my thoughts. Ms. Gilbert, when these issues first came up, you asked the court for an order of adequate cause so you could potentially make a permanent change in the parenting plan. Would you still want to do that? Or there's also Mr. Lawrence's thought that we just leave this until Mr. Gilbert gets the test and does the evaluation?
Yeah, I mean, I guess if we could leave it and give him more time, I guess. Yeah, I'm not sure what the best thing is, but if he did do it, then that would be best. Sorry. So yeah, I don't know if we can leave it for a while and see if he does something before making it permanent.
Ms. Gilbert, what would you think of having at least telephone contact between Mr. Gilbert and Max at this point?
Oh yeah, I mean, I believe they do. Yes.
They do already?
Yeah. I mean, I believe so. Yeah.
Okay.
How long is Max going to be punished and kept away from his grandparents and stuff? Over hearsay on the internet.
He never sees his grandparents that side anyway, but.
Mr. Gilbert, I
Else with
just want to remind you, it's more than hearsay. We have a sworn statement by your current wife that has raised these issues. So,
police reports say different.
Okay. Mr. Gilbert, are you in telephone contact with Max at this point?
Yes, I've talked to him a few times. Yeah.
Okay. Sir, I'm going to allow the telephone contact to continue.
What about his games and stuff?
Well, at this point, I'm not going to allow you to see Max until you get the hair follicle test and get the substance abuse evaluation. And I'm going to take Mr. Lawrence's suggestion, and I'm not going to set another review hearing. When those two things are completed and I can see the result, then you can put this back on the calendar for the court so I can look at it and I can determine what a safe visitation plan will be. But until I get those tests, I can't determine that.
So when they come up all negative, how can you take away all the priceless time I've missed out and everything else?
Well, that might be something I take into consideration, but I need to see negative tests before I can even consider that.
You'll never be able to make up priceless time I've missed with them.
Well, sir, I've had this order in effect since February 2nd.
I can bring my bank statements down and showing you I ain't got no money. Work right now is really slow.
All right. So what we're going to do today then is I'm not making any other decisions. I'm leaving the orders for the tests and the evaluation in place. And when they're completed, Mr. Gilbert can put this back on the trial calendar or on the court's calendar. Okay.
Thank you, Your Honor.
Your Honor.
That's it for today. Yes, Ms. Height.
I have on my schedule that Mr. Steyer and Ms. Wilson, or rather Ms. Steyer and Mr. Wilson, were to be on
Yes.
the docket today, and I don't see him here. He typically wants this case called first because of his work schedule. I don't see him here, and I just wondered if this needs to just be set aside.
There's an iPhone here. Mr. Wilson, Kimball Wilson, are you with us? He's not right now. Is Ms. Steyer here? And they're not. Can you hang on for a little bit? We'll give him
Sure.
more minutes, okay? This is a motion to modify the parenting plan because of the relocation of the mother. And I'm going to let you both address that, and then I'm going to tell you what I think we should do. So, Ms. Hernandez, do you want to speak first?
Hi, Your Honor. Yes, Your Honor. Your Honor, I wanted to file the notice of relocation and purposes parenting plan. But the clerk told me that I needed to file a petition to modify. I then spoke to an attorney and who told me that I needed a petition to modify or a motion under the relocation statute. I just wanted to move and get the new parenting plan scheduled under the relocation statute.
Have you moved already?
No, Your Honor.
When do you plan to move?
I'm planning to move by the end of April.
Okay. Mr. Martinez?
Yes. All right. Well, me and we sat down and talked about it a little bit, which at first I was concerned about my daughter moving far away, things like that. From what she says on her statements that she wants to move her from Portland, Vancouver area to find a different job, or I'm guessing to take her out of the States, find better job. Plus to be for itself to be with kids her age. Me and her boyfriend talked about it, and I'm like, "What do you mean? She has a sister here, all her family's on this side." At first, I didn't come to the agree, but I understand she needs the privilege. I'm guessing she's moving with her boyfriend, so I put my own notice. I'm like, all right, I'm gonna agree, but there's things that need to change, which she only agreed to the things that benefit her and doesn't really benefit anybody else, including itself. You know, I talked to them, sat down at home. We actually sat down at my home, and I told them I don't have a reliable car right now. My truck's wrecked. It's been on the shop for about 6 months. And I mean, you're the one moving, you know, like you got to put an effort to it. I took in consideration that I don't think she has a stable job, or I don't think she's moving because she has a better job out there. She's just moving because she has a boyfriend over there. You know, I don't know if she has a good job, or if he owns a home, or they're just gonna rent. I don't know what's gonna be, the best thing for Itzel, at this point. But I told her, like, I gave you the benefit of the doubt. Let's move, but let's change a couple things for now. I want to still see my daughter every weekend. She put in there no, because she's gonna be on the road for a while. I'm like, yeah, you should have thought about that before thinking about moving that far, But I mean, if she has better future for Itzel, then let's go ahead and work something out, which she never has been able to work something out, like it's always a here, it's always like a stop. And I'm willing to work with her. I mean, our divorce took freaking almost 3 years, and it was just back and forth. We could have never came to agreement. And I just want to make it fast and quick. Like I put in there, I want to be able to take my daughter to Mexico eventually. She says I won't be able to come back with her because, and I'm like, why not? I own a home here. I have a really good job here. My other daughter's here. It's like, there's no reason for me to stay in Mexico. Like, what do you think? I'm going to steal my daughter? No, like I have everything here, So that's what pretty much I'm letting her move, but I want what I proposed to her, like for now, you can pick her up. You can drop her off and pick her up one weekend, and another weekend we can meet halfway since I work Saturdays, till 10 a.m. I put a note in there. I think I filed a note. If you have any questions, you can call my job. Work, it's been really slow kind of right now because they just laid off swing shift last week. So I might be breaking. I might be better. We can work something else on, like she said, on her prior parenting plan that we can meet Fridays. That's only depending if I don't work. Because then the reason I work Saturdays is because Child Support Services says that since my pay is consistent, they use my overtime. You know what I mean? So my payments are always consistent. Periods. I got it adds up to my child support, which is like almost $600 right now.
So what I understand is you'll agree to the move, but we're not agreeing as what the visitation would be.
Yeah.
Okay.
Yes, she agrees. She agrees for what I proposed to her, and she can move. And because honestly, she deserves to be happy. I think that's the plan. She wants to eventually get married, and I think everybody deserves a second chance. She can remarry and do her life, but in reality, I'm really concerned if my daughter's gonna have a better future. Is she gonna move? Is she gonna have a better job out there? Is there really better opportunities? Because I think it's all the same. You can find any job anywhere, you know what I mean? And it's just depending on what you know how to do. And I told her that. I mean, at first I did tell her, like, I'm not gonna let you move her because I don't think there's better future for her. But in reality, we're all humans. We all deserve a second chance. If my daughter is gonna have a better future, I mean, it's a long ways there, but if she is, go ahead, let's give her, but I want to see her every weekend still. And for now, I told her I don't have a car. If you can work with me, you one weekend you do all the work, and another weekend we can meet halfway and go from there. And then eventually we can work a certain age. We can work a certain age that I can take her to Mexico, because my oldest daughter, we worked something out. It's like 8 years old. I'm able to take her to Mexico so she can be older and see her grandparents, things like that.
All right, let me Ms. Hernandez, if there's any response.
Yes, Your Honor. Everything that Mr. Martinez is concerned about, I have responded to his objection about moving. I don't know if you got a chance to review that, Your Honor.
I have reviewed it.
Okay.
So let me just tell you how the procedure works. When somebody files a notice of relocation, typically that would go to one of the judges, where you would discuss the relocation and the judge would address the parenting plan issues and would decide what the new parenting plan would be because of those changed circumstances. What I would like to do, however, in your case is I think we can get a quicker result and help us along. And first of all, what I'm about to ask you to do is, because it looks like you're pretty good at communicating and you're good at least discussing what you would like. So the court has developed a policy where these issues should go to what we call community mediation before the court steps in and makes a decision. And hopefully at the mediation, you'd be able to work out all of these parenting plan issues, including you should discuss your desire to go to Mexico with your daughter. So I'm going to refer this to mediation. What will happen is the mediation center will call both of you and find a time that works for both of you to get together and discuss these issues. That should be in a relatively short period of time, certainly by the end of April and well before the end of April. So that can be determined. So I'm going to make that referral, and then I'm going to set this case just before the end of April. So that would be on April 26th. And if you've been to mediation and reached an agreement, then great. If you haven't, then if I need to sign a temporary order to allow the move, I'll do that. I can talk about what visitation would be on a temporary basis, but then you'll probably have to set it before one of the judges to get a final order. So what you should do at this point is wait to be contacted by the mediation service and then cooperate with them so that you can get together and discuss this. Okay. And I think that's going to be a quicker result than if we go the usual method, right?
Yeah, like I said, I mean, I just wanted to, I try to make it as simple as possible. She still disagrees with simple things that I want to change, which we're not really changing much. But if she doesn't keep disagreeing, we're just going to get back and forth. And another 3 years later, we're here again. You know what I mean? But
so bring all that up with the mediation service when you talk to them. And they are specially trained to work through all those issues with you. Okay?
Your Honor. Oh.
Thank you.
Yes, go ahead. Then.
So are we gonna change the whole parenting plan? I essentially in the beginning of the parenting plan, I had the decision making due to the domestic violence. Is this basically, are we gonna change the whole? Because I'm only trying to change the schedule of the parenting plan, not the whole thing.
I think we're really just talking about the schedule.
Okay.
And I will make that clear in the order that I put together, that it's to address the schedule and the visitation schedule. Okay.
Thank you.
Okay. Thank you both. Good luck.
Thank you.
And I'm here, Your Honor.
All right, Mr. Chapman. So, Ms. Chapman, did you get the $1,000 check?
I did, and I actually again prepared something to respond to the papers that I was served yesterday because I did not have time to properly respond.
Do you want more time to respond to the papers he sent?
That's okay, as long as I can have it just a chance to read what I typed out. It's not too long, I think.
Okay, I will hear from you then if you want to read what you typed out.
Due to the untimely service and filing.
Can I ask you to speak up a little bit? You're coming through a little light in the courtroom here.
Due to the untimely service and filing on Bryce's behalf, I did not have time to properly respond. I was stalked and intimidated all day. I agreed to meet Bryce's girlfriend, Maggie. When I arrived to meet her, Bryce's mother was there, which scared me because she has filed false police reports on me, among numerous other things. So I chose to leave as she poses a threat to me, and I also was supposed to be meeting Maggie. They proceeded to stalk me to the dealership where my car was when my friend gave me a ride there to see if my car was done. They oddly enough showed up at the exact same moment, to which she later admits to a police officer after calling them to clear her name in fear that I would be calling on her for her continuous stalking of me and using the children as a pawn and following them home from school that day, causing them even more emotional turmoil than they already are suffering. She admitted all these things to the officer who advised me to file an anti-harassment order. As far as the things Bryce submitted to the court and the money owed, he did in fact pay the $1,000. Why and how he could come up with the money suddenly when being faced with jail time, I don't know. The receipts submitted for spousal support really got me because 9 of those receipts were deposits from when Bryce and I were still married and still lived together in the same home. If you look at the date, it says May of 2021. Bryce and I separated July 3rd of 2021. He had to deposit his paychecks into my account because he could not have a bank account of his own at the time. As far as the actual money order receipts he submitted from between the dates of July 2021 and November 2022 are inadmissible to this case because those receipts were in fact for child support, as I stated last week when we were here. As the spousal support order was never brought to the court or signed by you until February of 2022. So therefore, none of the receipts are admissible. So the spousal support he claims he paid me was also a lie. If you add up the total of all the money order receipts, it also adds up to $2,200, not $1,000 that Bryce stated he paid me. So many of the things said do not add up or make any sense. Bryce submitted his budget/bills, which the court never asked for that. He only shows here the amount of responsibility that he does not have. No rent, no house bills, none of those things. I have all of those, fully support our 3 kids and all of the above. And again, nobody asked for his budget to be brought forth today. If you got a chance to look at the child support income withholding notice submitted, the reasoning for them garnishing such a high amount is due to him being so behind in child support. In total, between this amount owed and child support, he owes a total of $24,000. So them garnishing 50% makes sense now seeing the paper. The $732 truck payment seems to be his primary responsibility, which is disturbing. And his girlfriend is also the primary on his truck. So if he can't afford his true responsibilities, maybe he needs to give that up. Your Honor asked for pay stubs for the last 3 months to be submitted, which he did do that, but here he also submitted an entire year of 2022's pay stubs, proving yet again what Bryce can and is capable of, and the living the kids and I were used to before I had to leave the marriage because of the addiction issues, mental and emotional abuse, and manipulation that was taking place for years. With all of this being said, and including the fact Bryce is not the one who filed these papers, but his mother and Maggie, in an untimely fashion, nor is it what the court asked for. It was even more lies in the simple fact he could clearly have paid me the entire year I've been dealing with this. I asked that the court order the previous punishment. I also asked that a strict payment plan be put in place. I've wasted enough time, energy, money, and stress with this just for him to sort of do what he has asked the second jail is brought up and then cause the things that were caused yesterday for me and the kids.
All right, thank you. Mr. Chapman, any response?
Yeah, Your Honor, I wrote up a statement to present. The number 744 or $744.54 is the amount that I have left for the month to pay for food and gas to get to my alternating job sites. I was unemployed for 4 months, September 2022 to January 2023. I struggled dealing with unemployment and was receiving no income those months. To pay the $1,000 to Miss Hancock/Chapman, I had to borrow from my dad, and I will have to pay this back. I handed that check to her on 3/19/23, and I have provided a copy of the money order. The payment of $250 the amount I thought was appropriate based off what I can afford. Not to mention $744.54 is the amount I have left when I have my children with me and for me to live off of. I try to provide for them what they need when I have them. I have provided a copy of most of my pay stubs for 2021 and 2022 when I worked at J.H. Kelly to show my pay and garnishment including child support. I have also provided copies of my pay stubs from Legacy 6 that show that 50% is being taken from my check, with other money orders that I have paid her on top of garnishment. I am trying to get my life on track. I apologize for all this wasted time with these motions. As I mentioned before, I was properly served to understand that I was causing more problems for myself. I am trying to provide for myself and my kids when I have them. I seem to get roadblocks with Miss Hancock/Chapman, and the rejection of my taxes is an example. I did my taxes this weekend, and any returns I received will automatically be garnished to my back child support. However, I received an email stating that they were rejected due to to Brody being claimed by someone else. In our final divorce paperwork, it is written that I am to claim only Brody. That is $2,000 taken away from my tax refund towards my garnished amount, not counting the effort it takes to refile and explain to the IRS, explaining my rejection and reasoning the rejection happened. On 3/21/22, my mom handed Brittany the copies of my paperwork you're reviewing at her home after several attempts of meeting up with her. She was supposed to meet at 12:30 at Target. No show. My mom went to the house and rang the doorbell while the car was there. No answer. My mom walked the kids from the school 2 blocks from the house. Brittany opened the door screaming and threatening to physically harm my mom in front of the kids. I have the police report from my mom as she reported to the sheriff's department. This is the second time that she has threatened my mom, and previous time it was physical. I ask that this is reviewed today as well. I have the statement from my mom that she filed. The officer's name is Officer Mosley, and his phone number is 360-99. If you allow me to, I would like to use the exact words she used towards my mom if you'd like to hear it today.
So that may be relevant in another setting. I'm not going to make a decision based on that interaction because we're not here for a restraining order or a protection order. We're here about the financial issues relating to spousal support and the payment for the vehicle.
Okay. So I paid $1,000 and I provided you my pay stubs that show that I'm garnished 50% of my wage, and it shows my February paychecks and my March paychecks of when I started with Legacy 6 and how they are deducted with the child support, and it says that on the pay stub. And it leaves me with, March paychecks, I have $744, and that's not counting my fuel, my food, my anything. I can't even rent a home. I can't even do anything with the amount of money I make doing what I'm doing. And I'm trying to live. I live with my girlfriend, and yes, I have a house to stay at, but that's all I have left is $744 for the whole month. So when I come to the $250 is the amount that I thought was appropriate, that's kind of what I can afford to, put towards it. I have a plan for spousal and car maintenance to be paid at the end of each month in the amount of $250 until the amount is gone, minus $1,000 that I had to pay. So if that $6,400 total brought down to $5,400, I could pay at the end of each month $250 until that's gone.
All right, thank you. Ms. Chapman, any response?
The 50% garnishment is due to no fault but his own because of him losing his job due to stealing from the workplace. So that garnishment would not be that big if he was not that behind in another form of payments. So to me, none of this is excusable. And as far as providing for his children when he has them, he puts my son in women's clothes that his mother provides for them. And I'm just tired of the excuses and the BS and him saying, I will give her $250 a month. We have heard this countless times. And the stories and the time that I've had to do that, he says, at the time that I've had to spend to do this stuff. And no, I couldn't even hold a job because of all of this stuff. There needs to be a punishment. I'm at the wit's end. This consumes my entire life, and enough is enough. And every time it gets down to the nitty gritty, he comes back with some things to submit that are not even accurate. And then after this, we won't get another payment. And then here we will go again.
So what would you like to see happen?
The previous punishment of the 5 days to be ordered, at least, and then a strict payment plan to be put in place.
All
and
right.
if he did not have almost $1,000 truck payment, he could afford more.
Your Honor,
my bills
I'm ready to move
my
forward.
bills and supporting my children far outweigh his 3 bills that he has. I'm ready to move forward too with my whole life and be done with this. It's so stupid. It's a waste of everyone's time.
All right, Ms. Chapman, I'm ready to make a decision here. On March 15th, I entered a bench order requiring Mr. Chapman to pay $1,000. That was the first thing. The second thing was to provide receipts of all spousal support payments he made. And 3 was to provide 3 months of wage stubs showing the amount that was garnished from his paycheck. He did pay the $1,000. He provided what he indicates as spousal support payments. Those are from 2021. Ms. Chapman disputes whether they are, because apparently some of those are prior to the date of separation, but that will be worked out in whatever credit, if any, those might provide. And Mr. Chapman did provide wage stubs going back more than 3 months, along with the administrative order from child support showing the garnishment. The current pay stubs show that Mr. Chapman makes close to $4,000 a month, but with the garnishments and taxes and so forth in February, I believe, he only took home around $1,627. And he is on track to do that or less in the month of March. I'm going to find that he did comply with my order of March 15th. And so I'm not going to order any jail time. Looking at the income that Mr. Chapman has provided, I guess I'm going to tell you 2 things, Mr. Chapman. There's an order in place for spousal support of $250 and also for, I believe, a car payment of $250. Plus there's back support that's owing. The last time I calculated that, it was around $13,000. I know you may dispute that amount, and that's something you could bring up to the court at a later time, but that's kind of what the financial situation looks like. The spousal support and the payment for the vehicle are still going to accrue at $500 a month. If you make $250 a month payment every month from here on out, and I would like those payments by the 10th of the month, then I will not hold you in contempt. But I want you to understand that doesn't fulfill your total financial obligation, that if you don't pay $500 a month, every month there's going to be another $250 added to whatever judgment is owed. But if the $250 is paid, then I'm going to find that you're not in contempt. And I'm going to leave things at that. If Ms. Chapman, if the $250 is not paid, then you're free to bring that to court again. Mr. Chapman, the jail time is still on the table. And if there's another contempt hearing, I'm probably going to order that. You have offered to pay $250 a month, looking at your income and the issue with the garnishment. I'm going to accept that is about the limit you can do right now. If Ms. Chapman is aware that you're earning a lot more money than what you're earning right now, then we're going to adjust things and you'll have to pay more. But right now I'm going to order the $250 a month. I hope that will be paid, going off into the future. You're still going to have the judgments against you that will have to be satisfied at some time.
Your Honor, I have a question.
Okay.
In our final paperwork, the spousal maintenance or the spousal support should have ended or should be ending, and it should have ended already. So that payment should be stopped. So I would be
never started.
I would be making just back payments on that, what I owe up to. It wouldn't accrue
I
anymore.
also asked for it to
Okay,
continue. for
before
another year.
we argue that, I don't have that paperwork in front of me. Given the back support, you're still required to pay $250 a month.
Yes.
At some point, I assume one or the other of you are going to bring the issue to court to calculate whatever credit is owing. And I suspect there'll be a disagreement, but I'm going to need more information before I can address that. Right now, regardless of how we look at it, you're going to owe $250 a month, whether it's current spousal support or past spousal support. Okay.
Okay, Your Honor. Another question: how will I be served the papers in the future? I mean, with the communication and how things are going, can we plan on doing like a mailing thing back and forth instead of any confrontation?
You don't
with-
send your mom.
Ms. Chapman, do you have any objection to Mr. Chapman mailing you legal documents in the future?
You are just required to serve them properly and not use an abusive person to do so, who files fake reports.
All right. Sounds like
That's
she's
it.
not.
I agreed to meet up with Maggie and then met there and saw his mother in the car and then turned around. That was it. And so I actually went to the courthouse to pick up the papers myself because I know how to do the things, and they weren't scanned yet, so I couldn't pick them up.
All right. Mr. Chapman, it sounds like service needs to be done. If it needs to be in person, you can do it in person. You'll need to do that somehow.
Having the
Use
kid's
a
grandmother
third party to do that.
do it is I mean, come on. And stalking like that, yeah. He could have done it. I've served him personally the whole time.
But Ms. Chapman, you're actually fading away. I'm not able to hear what you're saying.
Like I've served him like the whole time, so he could have served me like he actually stated in the first message about giving me the papers. He said he had papers for me if I wanted to meet him, and then it turned into Maggie, and then all of a sudden I was being blindsided by the person who he knew better than. It was an intimidation thing. And if I'm being clear, so he is supposed to still be required to do the $500 a month and then also the $250. I'll just go pick up the papers. It's okay. You don't have to reiterate.
All right. I made a decision and I'll put that in a bench order. And again, if the $250 is not paid by the 10th of the month, that'll begin April 10th. Then I guess Ms. Chapman can bring another contempt. Okay,
and I think the order was signed about continuing the spousal support and stuff for another year since it actually never started because it never got paid. So I'll pick up those papers today to be clear on that too.
Okay, I understand that. Well, I did enter judgments for the spousal support up until recently. So
yeah, it's been a minute since I think that one was done, so I don't remember anymore.
I'm not addressing that right now.
Yeah.
Want to address that? Bring
That's fine. I can go pick all that up. You don't have to. Yes.
Okay. Thank you.
Okay. Thank you.
Hey, Your Honor, this is Josh Gray.
I heard Josh Gray, and I haven't called your case yet.
Yeah, you called my case first, but I was just released from work and
just a minute here. No, I didn't call your case yet.
it's with Tanya Hansen.
Yeah, I did not call that yet. Just hang on. I'll call it in a moment. Okay. Let's go to Steyer and Wilson. I see Mr. Wilson's here.
Yeah.
Is Caitlin Steyer here?
Your Honor, I did call her and heard back that she was going to try to get on, but I don't see her here.
She's not in the waiting room.
Okay.
So my records showed it looked like the mother was having one visit per week that was supervised. There was a recent test that required SUD, intensive outpatient treatment. Do you know if she's been receiving that, Ms. Hyatt?
I do not, Your Honor. I've not heard from her, and I found nothing in Odyssey
Mr. Wilson, do you know if Ms. Steyer's been going to treatment?
I honestly do not know. I know she should have got her parenting class taken care of, I believe.
All right. Well, Mr. Wilson, is you're doing the primary care for your child right now?
Yes.
Like one visit per week to Ms. Steyer. Is that going okay for you?
You actually said it was 2 visits a week.
Okay.
And it's, yeah.
Well, because I think where we're at is, I don't know that we need to keep coming back here. We're not getting compliance by Ms. Steyer with what I need in order to increase her visitation or to move it from supervised to unsupervised. And until she can show that she's doing the outpatient treatment, I'm not going to make a change. So I think what I'm going to do is, I guess, not set a review date at this point. And if there's a change where she engages in treatment and wants to come to court in order to get additional visits, she can do that. But at this point, I've been putting this case off, every couple weeks or every month, hoping to see that she engages in treatment, and then I can make some adjustments. But I just don't see that happening. Ms. Height, do you have any thoughts at this point?
That seems the best course at this point, Your Honor. There just hasn't been very much movement. And at this point, I believe their daughter is in a safe place, and that's the best thing for her at this time.
Okay. So, Mr. Wilson, I'm not going to set another review date. And if you want to let Ms. Steyer know if she engages in treatment and wants to bring that to the attention of the court, then I will certainly consider a different visitation schedule.
Can I go to the courthouse and get a copy of that in paper, like from the courthouse? Because I don't think she's going to believe me if I say it to her.
Okay, that's fair. If you want to wait a couple days, what I usually do is type up what I call a bench order and file it in the case. I'm going to need to prepare that.
No, that's fine, but I can grab one in a couple days.
It may be as late as Friday before I get that completed. So maybe if you come next week, you'll be able to get a copy of it. Okay.
Okay. And do I keep her visits the same?
Keep the visits the same. They should be, if they're 2 a week, they should be supervised. That's fine.
Okay.
Okay. Thank you, sir.
Appreciate it. Thank you.
Hello, Your Honor. Thank you, Your Honor.
Ms. Mills, you brought a motion to waive the guardian ad litem fees.
Yes.
You find that I know there was an order here. All right, I'm going to grant that order.
Thank you, Your Honor.
And I want to talk to you about something else here in a minute.
Okay.
Are you on some form of public assistance?
Yes.
What is that?
Food stamps and TANF, and I'm also receiving WIC.
Okay, I've signed that order waiving that. Here's what I wanted to talk to you about is I've got 2 cases. One is Samuel Mills versus Rebecca Mills. And the other is Rebecca Mills versus Samuel Mills. And as far as I can tell, they both deal with the same thing, which is disillusion.
Yes.
And it seems to me those cases should be consolidated.
Yeah, I'm okay with that.
Okay. And is Samuel Mills here? All right. I'm going to do that. I'm going to consolidate them, I guess, under the earlier case. I'm going to consolidate them under the 7-2 case.
Okay.
And then I'm probably going to have to do an amended GAL appointment indicating that it'll be county pay for.
Okay.
Yes,
Ms.
Your Honor.
Day,
And I wanted to make the court aware, I've not had any response from Mr. Mills. So I'm going to send out a second letter giving him a date certain to respond by. And if I receive no response, then I would just file a report based on the information from mother and that I've already gathered and submit for payment from the county. He's not participated yet, and I don't know that he's going to.
All right. Okay. So on the Mills case, then I'm going to do an order to consolidate the two cases. I've signed the order waiving the guardian ad litem fee. I'm going to change the appointment to reflect that it's county pay. And Ms. Day is going to make one more attempt to get a hold of Mr. Mills. If not, she'll do a report based on what she knows, I guess. How long out should we set the review hearing, Ms. Day?
I think it'll probably take me 30 days to get the report finished. So I'd say 60 days.
So that puts us to about May 24th.
Yep.
All right, Ms. Mills, then we'll be back here on May 24th to consider Ms. Day's report and make additional decisions at that time.
Okay. I have a quick question, if that's okay.
Sure.
We have a vehicle that I've been driving. I'm not sure when is the best time to address this. I know we kind of have a lot going on. I've been driving a vehicle for a couple of years now. It's in my possession, but it's all in Samuel's name.
And you'd like it to be moved over into your name?
I would like for him to be ordered to continue paying it like he has been and keep the insurance on it and keep making the car payment as he always has.
All right. Typically, that would be addressed by having you file a motion for temporary orders.
Okay.
Request that.
Okay.
And you can do that on this docket. I won't give you the date, but if you can get those, get that motion, and it may be the only thing on there is to require that he continue to pay the car payment and the insurance on that vehicle.
Okay.
Then we can address it at that time. But I think Mr. Mills is entitled to notice of that.
Okay.
Before decision. Ms. Steyer,
Okay,
I think you have just joined us. You want to unmute yourself?
Yes, I'm here.
Ms. Steyer, I called the case already. And I wanted to check in with you though. Have you started treatment, substance abuse treatment?
So I haven't been able to make it to the court office to actually know what was said last court hearing. I tried asking Kimball. He didn't really tell me much. So I didn't know what I was supposed to be, what the new regulations were. I did complete the family class though from the court hearing before then. So I do have the certificate. I just haven't been able to turn it in yet.
Why don't you file that with the court clerk? They can put it in this case file. So before, right now, apparently you're having supervised visits with your child twice a week. That's what I understand. Before I modify that, I want to know that you're getting treatment that was recommended for you. And that's apparently outpatient treatment. So once you start that, if you want to change the visitation from where it currently is, then file a motion with the court that you want to change and attach some record that you've been attending that treatment. And I will at that point consider how to modify the visitation. Okay. All right. And that's what I told Mr. Wilson. And so at this point, it's kind of in your court to get the treatment and then bring it back to court for me to modify things. All right.
All right.
Okay. Thank you, Ms. Steiner.
Thank you.
Here, Ms. Corey, in the file, I didn't see an order. So I did an order yesterday for you to be appointed, but obviously you know that I appointed you.
I did get that this morning. And I had a couple questions actually about it.
Okay.
So it's not indicated none of the boxes under number 5 GAL duties are checked.
I usually check the first one is, and so that's my mistake. I'm sorry.
Okay. And Also, it's not indicated whether that's private or county paid.
Right now it would be, again, that's a mistake. I think, let me look in the file before I commit to this. I believe Ms. Hanson has an order to waive fees, so her portion would be paid by the county. And I don't know that I have a same declaration from Mr. Hanson. So I'll look at that order. I may have to do an amended one, but usually I want to know everything relating to a parenting plan and then everything addressing the safety of the children.
I thought so, but I just wanted to confirm. Thank you.
Let's start, I guess, with Ms. Hanson. I have a temporary family law order that was provided to the court. And you indicate you'd like an emergency restraining order and then a parenting plan. I may have missed it. Was there I see a motion for a restraining order. Let me see if one was entered here. I don't see that had been done. Are you still requesting a restraining order?
No, Your Honor.
You're not. Okay. If I sign this temporary order, can I cross that part out?
Yes.
Okay. So what we're looking at then is determining the parenting plan between you and Mr. Hanson. Is that right?
Yes.
Are you, do you have anything informally in place at this point between the two?
Not at the moment.
And let me check one other thing. So your child is Oakland?
Yes, Your Honor.
Is Oakland staying with you right now?
Josh has her at the moment.
Have you seen her recently? Is she going back and forth?
He's keeping her away from me at the moment.
Okay.
Your Honor.
I'll hear from you in just a moment. Okay. How long has that been the case, Ms. Hanson?
It's been about 2 months now.
All right, Mr. Hanson, what is your reasoning to keep Oakland away from seeing her mother?
I have emergency custody. I've attempted to send the paperwork over through email, but it didn't go through. And I currently just got a new email, and I just sent it over this morning.
Who gave you emergency, sir? Who gave you emergency custody?
The state of Oregon on January 26th.
Okay.
Also, she keeps quoting that I'm married to her, but I have never been married to her.
You're not Mr. Hanson.
I am not Mr. Hanson.
So, let me pick a date here. When this was first filed was February 17th. Prior to that date, where was Oakland living?
She's been in my
With
care.
me, in my custody.
Okay. Ms. Hanson, why don't you answer that first? Where was Oakland living on February?
I've always taken care of her since the day she was born. She's always been in my care.
And was that in Washington?
Yes, Your Honor.
Okay. All right. And then, Mr. Hanson, did you file an action in Oregon?
Yes, I did. On January 26th, and I was granted emergency custody on that day.
How did Oregon have custody or jurisdiction over Oakland on that day?
I've been here for 6 months, and so has my daughter.
Okay.
That is false, Your Honor. I have proof that he was living with his ex-girlfriend in not Richfield, but Yelm area in Washington.
That is false.
Sir, do you have the case number, the Oregon case number?
Yes, I did.
Got it. And what county is that?
Lane County.
In Lane County. Okay. What we have is an issue of jurisdiction in this matter. And there's a specific statute that provides that a judge from Lane County and myself need to contact each other. Both of the parties can be present at that, and determine which court should have jurisdiction over this matter. And so before
Okay,
I
Your Honor.
else, and honestly, before I enter a temporary order, we're going to have to carry out that hearing. That may take a couple weeks. And Ms. Corey, you can be part of that hearing also. My judicial assistant, who is Autumn Terry, will probably be contacting you to give you the date of the hearing and what I assume will be a Zoom link in order to attend that hearing. Okay. But when we have a jurisdiction issue, and it comes up from time to time, this isn't all that unusual, then this is the way we're going to have to resolve it. So we need to decide between Lane County and myself whether Lane County is going to have jurisdiction over Oakland or whether Cowlitz County will have jurisdiction. Okay. And again, both of you will have input into that decision. All right. So I think things are going to be on hold right now. I will set a review date down the road. I'm going to set a review at the end of April, just so we know which way this is going to go. So that will be on April 26th at 9 a.m. All right. I think that's what we're going to have to do at this point. It may be helpful for me, Mr. Hanson, if you would file a copy of the order that you're referring to in the Cowlitz County case.
Okay.
And that way I'll be able
How do I go about doing that?
What's that?
How do I go about doing that?
Well, you would put a page on it that has the Cowlitz County case number on it and caption. And all it has to say is Lane County Court, Lane County, Oregon Court order. And to the clerk's office and ask them to file it in the case. But you got to have the Cowlitz County case number on that so that you know where to file it. Okay.
Thank you, Your Honor.
All right. So you should expect the court to reach out to you to schedule that hearing. So I have a thank you. Temporary family law order. And it looked like there were not many requests made. The only order, and then I'm going to talk to you about more things, but on number 14, it says the petitioner will claim the child on the 2022 tax returns and even years thereafter. The respondent will claim on the odd years. Is that agreed, or is there a conflict on that?
No, that is not agreed, Your Honor.
It's not agreed.
And then I assume, are there issues with the parenting plan that, or parenting the child at this point? You guys are agreed on that part?
Yeah.
I think so.
Okay. So you could sit down and put together an agreed parenting plan and submit that to the court.
Well, I actually made up the parenting plan, Your Honor, and it says here in his response that he does disagree with parenting plan, but his reasons for it looks like it's more pertaining to the taxes than the parenting plan. So I think he's in agreement on the parenting plan. Maybe was just a little confused while filling out the paperwork.
Is that a fair statement, Mr. McClellan?
Yeah, I have no problem with her seeing my child at all, our child.
All right.
Whenever you want.
Well, do you want to address the tax issue right now and see if we can get to a resolution?
Sure.
Yes, that's exactly what I would like to do, Your Honor.
So, Mr. McClellan, why don't you tell me what you would like to see and why, and then I'll go to Ms. McClellan and she can respond.
All right. Thank you, Your Honor. Ever since we split up, my kids have been living with me. I take care of her full time, provide all of her housing, doctor's appointments, schools, driving school, everything. And she eats like a horse, so teenager. Other than that, I don't have any really issues with the divorce, but a couple of things. But with the taxes, I feel that DeAndre does not deserve the tax break on that because child lives with me full time.
You receive any payments from Ms. McClellan?
I receive child support.
How much is that?
It's about $350 a month.
All right. So are you asking for the tax exemption every year going forward? Or
he's only got 2 more.
What's that?
He's only got 2 more years that we're going to be claiming her on taxes anyway, because she's almost 17 now.
So 2022 and 2023?
Correct.
Well, if she remains a dependent, if she goes to college, then you would be able to claim her past 18.
Okay.
I don't know what her plans are, but
yeah, she's planning on going to college.
Okay, so it may go forward beyond the time she's 18.
Okay.
So what's your position on having 1 year with you and 1 year with Ms. McClellan?
As far as the taxes go?
Yes, the tax exemption.
Like I stated earlier, I don't see her putting in enough effort to claim those.
How often does she see Harley?
Every other weekend, I believe.
Okay. Have you filed your 2022 taxes already?
Yes, sir, I have.
And I assume you claimed Harley at that point.
Yes, sir, I did.
All right, Ms. McClellan, do you want to respond?
Yes, Your Honor. So I believe that I should be able to claim our daughter on the 2022 taxes, at least this year and every other year going forward, because not only do I pay the child support that I am ordered to pay, but I also see her, yes, every other weekend, but also there are some weekends where we throw in an extra weekend for her to come in with me. For example, in November, I was helping her with her school homework because her and I both, she's taking college classes in addition to her high school classes. And we both took nutrition. And so she wanted me to help her out with that. So there's different instances like that where I'll take her more than every other weekend. And I also incur expenses. Dave and I had agreed to do her hair appointments. I've paid for one, and I believe he's paid for 2 of them. So it's my turn to pay for the next one. I've just paid for her permit. And I also take her to different appointments whenever Dave's not available to take her to appointments. I've also bought her shoes and some undergarments, including socks. I've just recently drove her to her driver's ed school because Dave was unavailable to take her to school. So I feel that I am also putting in just as much as I possibly can. Last year, I made $14,000. And in that $14,000, I did pay about $2,400 in child support. I do owe back child support, but that's only because my mental health became an issue and I needed to separate from my job to take care of myself. And that back child support, I'm going to ask for a modification during our divorce hearing. But right now, this is the only thing that I would like to have addressed immediately, and everything else can be addressed in our divorce hearing. But I am back at work and I'm thriving. I just received a promotion, so I have every intent of getting my back child support paid up to date. And back in 2020, we filed the taxes together and we split the money. And then in 2021, he claimed both of the children. And this year, I would like to claim them since, there was a time that I was paying $900 in child support before I lost my job due to my mental condition.
You have an older child that's now over 18?
Yes, that's correct, Your Honor.
Mr. McClellan, any response?
I received custody of both kids when we were doing the previous divorce. They've been living with me nonstop. She does help out when I'm not available, but I've paid already half of her Harley's driving school. I've already got a car for her. Yeah.
So I view the exemption as not just based on where the child lives primarily, but what the financial commitment is by the parties. And where somebody is paying child support and paying it regularly, then it's my view that they're entitled to an exemption on some basis. So kind of the first threshold is, does Ms. McClellan ever get the exemption? And my answer to that would be yes, she should. The second question is, when should she get it? And a typical order in these cases is that you have to be current on child support in order to claim the exemption. So she's indicated that this year, due to various issues, she's got some back support owing. So I think it's appropriate that the exemption remain with Mr. McClellan for 2022. And then for 2023, so long as Ms. McClellan is current on child support, then she would be able to claim the exemption. 2024
back child support and everything.
What's that?
As long as she is current with the back child support and everything.
Yes, that will have to all be made up. And then, and it sounds like she's going to do that. So, and that would be as of January 31, 2023, that everything would have to be current. You know, she might be behind all year long, but if she makes it up on that last day, then she'll be able to claim. And then 2024, if Harley is still a dependent, you can claim her, and then that would go back to Mr. McClellan. 2025 would go to Ms. McClellan. Okay, so I'll do an order to that effect. Well, I'll write that on the temporary orders here.
So petitioner will get the even years and the respondent will get the odd years? Or
you're the petitioner, so it's the other way around.
The way around, yes.
And the respondent will get the even years.
So, Your Honor, I have a quick question. So for this year's, when I file this year's taxes, she has to be current before she can claim Harley, correct?
Her first time taking the exemption would be for 2023. And as I said, she needs to be current on December 31, 2023 in order to claim. I'm going to add that to the temporary order.
Okay, thank you, Your Honor.
Sign that order modified as I've indicated. If you can agree to a parenting plan, I guess I would encourage you both to put that together and sign off on it, and that could get entered. And then if you feel you need to have a hearing regarding the terms of the divorce itself, then you'll need to set this on what we call the trial setting calendar and set it before a judge for a trial on that issue.
Okay.
So that's how that will do.
I appreciate the information. Thank you.
Thank you, Your Honor.
Okay. Any other questions from both of you?
No, that'll be it. Thank you.
Okay. Thank you. I'm not going to set a review hearing. I'll just leave it for you to schedule it for a trial. Okay.
Okay, great. Thank you.
All right. Thank you.